Are you tired of filing multiple bail applications and they are being rejected again and again? Knowing when to file a bail application is hugely important for you because not only it decides whether your bail application is going to be accepted or not, but also it can save you a huge amount of money as those bail applications are costing you money in the form of advocate expenses, filing expenses, etc. and etc. So, what is the right time to file a bail application? You should file a bail application when there is a change in circumstances in your trial. Now, what is this change in circumstances? In order to understand this, we have to first look at the 5 different stages in a trial where the question of bail comes up before the court. The first stage. The question of bail first comes in the form of an anticipatory bail before the High Court under Section 438 of the CRPC. Here, in this stage, the person is yet to be arrested. He is still free. And in some cases, even an FIR has not been filed. The person is fearful that the police is going to arrest him very soon. So he goes to the High Court and prays for an anticipatory bail. Now, if he is granted anticipatory bail by the High Court, if he is arrested by the police, he will have to be released by the police on bail. The second stage. Here, the person is arrested by the police. Now, this is a change in circumstances. If the High Court did not grant you anticipatory bail and you were not arrested then, but now you are arrested by the police. And so this is a change in your circumstance. So now you can file a regular bail application under Section 437 and 439 of the Criminal Procedure Code. Remember, anticipatory bail is always filed when the person is still free, and regular bail applications are filed when the person is arrested and he is behind bars. Now, remember that this is the very early stage of the investigation by the police. Some incident has just happened and the police has just begun the investigation. So from whatever little evidence and materials on record or witness statements which are available before the court, which are collected by the police, the court has to make a decision on whether the person should be granted bail or not. Now, sometimes what happens is that the police takes years and years sometimes just on the investigation. And mostly it is seen that the poor people who cannot hire lawyers, they keep languishing in jail for years without even seeing their investigation being completed. Charge sheet has yet to be filed from many years. So in this case, you should take recourse under Section 167, subclause 2 of the CRPC. It says that for any offense punishable with 10 years or more, where the police does not complete the investigation within a period of 90 days, then the person will have to be released on bail. And for any offenses which are less than 10 years, then the police has to file charge sheet within the period of 60 days. Investigation must be completed within a period of 60 days. Otherwise, he will be released on bail. Now, this kind of bail is called default bail. Because by very nature, if the police commits the default by delaying the investigation, then the person, his right to liberty has to be upheld and he will be released on bail. Now, this Section 167 was inserted into the CRPC in the year 1978, and it has a very laudable object behind it. Because as I have previously stated, that the poor people could not afford the lawyers they could not move bail applications, and they languished before in the jails for years at an end, and even the charge sheet was not filed. Now comes the third stage. In this stage, the police has completed the investigation and has filed a charge sheet. It is in this stage now that the court gets to view the clear picture about the involvement of the accused in the crime. From the various materials which are available in the charge sheet and other witness statements, the court gets to view the evidence in its entirety. And if it is a serious case and the court views the evidence and it sees that it is a high likelihood that the person did not commit any offense, then the person will be granted bail. Now, if this person is still not granted bail, then in the fourth stage, what happens is that he is awaiting his trial to begin. Charge sheet has been filed, but his trial is yet to begin. Now, as you are all aware of the huge number of backlog cases in the pending before the Indian courts, and these backlog cases are rising year by year, every year, and the people, they keep languishing in the prisons for years and years without even seeing the beginning of their trial. Now, in this stage, the person has to seek recourse under Section 436A of the Criminal Procedure Code. Section 436A states that if the person he is detained in prison for a period of half of the period of time for which the offense brings. How do I explain this? Suppose the offense is of 10 years punishment, and if the person is in jail for whatever period, whether he is awaiting the beginning of his trial or on the charge sheet is only not filed, but if he is in jail for 5 years, then the person will have to be released on jail under Section 436A. He cannot be imprisoned for more than half of the period of imprisonment which the offense entails. 436A of the CRPC. This also is a complementary provision to the Section 167 subclause 2 of the CRPC. It protects the poor people who would have otherwise have been left with no remedy to attain bail or be released from prison. Now, the fifth and the final stage. Here, let's say that even till now the person has not been granted bail and the trial has finally concluded and the person is convicted. Now, naturally, he will file an appeal before the appellate court. And if the appellate court admits the appeal, then the person needs to file another bail application. Now, this is another change in circumstance because earlier the person was not convicted. He was only awaiting trial or the trial was going on. But now he is convicted. So this is another change in circumstances. So he will file a bail application under Section 389 of the Criminal Procedure Code. Now here, the court will consider a variety of factors such as the length of the sentence which has been awarded to him. If it is a short-term sentence, then it is highly likely the person will be released on bail pending that appeal. So, the change in circumstance keeps on happening in every stage of the trial. Earlier, in the first stage, the person was not arrested. In the second stage, the person is arrested, but the investigation is still going on. That is a change in circumstance. Now, when the police completes the investigation and files the charge sheet, that is another change in circumstances. Then he can go for filing another bail application. Now, when the charge sheet is filed, but the trial was not complete, but when the trial is completed, then that is another change in circumstances. Filing multiple bail application in the same stage of the trial, it is highly likely that those bail applications will not be accepted once it is being rejected by the court. If the High Court rejects one bail application in a certain stage of the trial and without any new change in circumstances, it is highly unlikely that the courts will entertain another bail application in the same stage. So, if you restrain yourself from filing multiple bail applications in the same stage of the trial and wait for a change in your circumstances, you will find that your chances of your bail application being granted are rising drastically. And in the process, you can save a lot of money because you on those advocate fees and other filing expenses. So by now, I hope that you got a clear picture of the right time to file a bail application. So dear viewers, if you like this video, please like and share the video to your friends, and also comment in the comment section your views and your opinion on the topic. And please subscribe to my channel and don't forget to press the bell icon so that you guys are notified whenever I release a new video, because I will be coming up with more interesting topics like these very soon. Thank you.